Good morning, all. This is let me pull up the documents for this. This is the matter of Regina versus Powell and Jean-Paul Pete. Appearing on behalf of the appellant are Counsel Feldman and Gann. We're ready. You may begin.
Thank you. Good morning, Your Honors. My name is Liam Feldman, and along with my co-counsel Zachary Gann, we present the Feldman and Gann Legal Counsel. While the respondents argue that Mr. Pete and Ms. Powell's Section 9, 10, and 8 charter rights have been violated, and that the evidence collected should be excluded from trial under Section 24, the appellants respectfully submit that there was no such infringement, and therefore there are no grounds to exclude any evidence. This case is about the power of police discretion, the complicated task of defining psychological detention, and the legality of cell phone searches. At the core of each of these items is the constitutional issue involved in granting the power afforded to the police to maintain community and officer safety while not interfering with each individual's reasonable expectation of privacy. Within our appeal, we submit 4 main arguments. Firstly, we submit that Justice Stern erred in his analysis of when the vehicle itself was detained. Secondly, we submit that the actual detention was unquestionably lawful within the given evidence. For our argument, we find that the time of detention was much later than Justice Stern identified, and contains greater justification than the time originally submitted. Thirdly, we submit that the search of the cell phones was lawful and fell soundly into the requirements for an unwarranted search. Under the precedent set by Ontario law and from across Canada, the evidence and interpretation of the charter supports the search of the cell phones for drug investigations. Finally, we submit that even if these issues are considered a breach, the severity of the crime is too great and the violation is too small for the evidence to be excluded under Section 24 of the Charter. Thank you.
Good morning, Justices. My name is Zachary Gann, and I will be appearing for the appellants on issues 1 and 2. For issue 1, we submit that Justice Stern did not err in finding that the police detention of the vehicle and its occupants was lawful under Section 9 of the Charter. This case has to do with the corroboration of information by police. Our remand states that if the facts objectively indicate the possibility of criminal behavior in light of the totality of the circumstances, the objective component of reasonable suspicion standard has been satisfied. We are submitting that when the vehicle was pulled over, the standard of reasonable suspicion had been achieved. What's notable in this case is the consistency of the facts that the officers observed. The information provided by the tip line included a description of the vehicle, a time of day, and a place, all of which matched up with the officers' observations. This is what provides credibility to the tip. In addition, the pattern of behavior of the students approaching the vehicle, all for short periods of time, and all in a manner that allows for some form of exchange, again indicates the presence of illegal drug trafficking. In paragraph 32 of the respondent's factum, they submit that these interactions with students could have been justifiable or related to other activities. However, in R.V. Williams, the court states that the standard of reasonable suspicion is not frustrated simply because the factors urged in support may also give rise to an innocent explanation. Justice Stern correctly notes that this is a case where the police corroboration of information is what gives rise to a ground to detain. The combination of the information from the tip line, the observations made by the officers matching the same information, as well as the behavior of the students approaching the vehicle, is what gives rise to the possibility of criminal behavior, and therefore the standard of reasonable suspicion has been satisfied. Now, to wrap up issue 1, and just to preface issue 2, we would like the court to note that we are submitting that Justice Stern did err in finding that the vehicle and its occupants were detained when the vehicle was initially pulled over. Rather, we submit that detention only occurs later on in the interaction. However, the finding that the court makes on this point has no effect on the analysis of Section 9. Even if the court finds that detention occurred when the vehicle was initially pulled over, the standard for reasonable suspicion has still been satisfied. If the court finds that the accused are in fact only considered detained later on in the interaction, this would only further strengthen our Section 9 argument. The court would be able to include all evidence the officers observed while talking to the accused for an analysis of reasonable suspicion, including the lie told by Mr. Pete and the large amount of cash. While the court's finding on this point does not have an effect on the Section 9 analysis, it does have a major impact on the Section 10 analysis, and therefore I will discuss that at length under issue 2. So the majority of issue 2 boils down to when the accused are considered detained by the officers, as their Section 10 rights are only triggered when detention occurs. We respectfully submit that detention only crystallized later on in the encounter, not when the vehicle was initially pulled over. So detention comes in 2 forms, physical and psychological. Physical detention is clearly not a factor in this case. Psychological detention, however, is far more complex. There are 3 factors to consider in determining whether a psychological detention has occurred. The first are the demographic characteristics of the individual. Mr. Pete and Ms. Powell are both adults, both physically abled, and there is no indication that they are of any minority status. The second factor to consider is the circumstances giving rise to the encounter. From Mr. Pete and Ms. Powell's point of view, their vehicle was pulled over for a traffic stop. At this point, a reasonable person would not believe that their liberty is being inhibited. The same principles that allow officers to stop people on the street to ask general questions, as outlined in Grant, without triggering a psychological detention, should as well be applied to cars on the road. The third factor has to do with police conduct in the interaction.
Counsel, sorry to interrupt you. I have a question about the second factor. Can you just help me with the facts? Did the police activate their emergency lights before they pulled over the 2 accused in this case?
I don't believe it outlines that in the case that we were given. And
so would they? Is your position that they would have been free to just drive away?
No. So Grant provides that an individual is not considered detained if they are just simply delayed by an interaction with the police. Very well, when an individual is walking on the road and stopped by the police to ask general questions, they can't, or it is reasonable to think that they are there to interact with the police, but that's not the standard for psychological detention. If a person is simply delayed, it doesn't mean that they're psychologically detained. It's that if their liberty and their liberty interests are being inhibited. So we submit the same way that if I was walking on the street and an officer stopped me and asked me questions about what I had seen previously, I could choose not to answer, but as well, it doesn't constitute a psychological detention, and officers need to be afforded that power on the roads as well, which can be argued as an even more dangerous and volatile area of our society. Does that help answer the question?
Thank you. Yes, I have your position.
So on to the third factor. This has to do with the police conduct in the interaction, particularly the language used and the nature of the questions asked by the officers. The encounter starts with the detectives approaching the vehicle and making a request for the accused's license, registration, and insurance. The assertion that officers are allowed to make general inquiries about an individual's identity is supported in both Grant and Subaru. This is not a particularly unusual or invasive question, and therefore does not meet the requirements for a psychological detention. Next, Detective Van Gundy asks Mr. Pete and Ms. Powell where they were coming from. The Subaru case also allows officers to ask general questions about prior whereabouts. The question's objective is to better the officer's understanding of the situation and to determine if the individual in question might be engaging in illegal activity. Applying the same principles used in the Subaru case, this question falls under a general investigative inquiry that is neither restrictive nor invasive enough to constitute a psychological detention. In the next stage, Mr. Detective Van Gundy, if something is wrong, to which the detective replies, "Not answering my questions is something wrong." So analyzing this response is complicated due to the extreme subjectivity involved in interpreting it. A similar problem about interpreting ambiguous statements arose in Subaru, where an officer told Mr. Subaru, "Wait a minute, I need to talk to you before you go anywhere." Although the courts recognized that there might be a conflict of interpretation, ultimately it was decided that there was no psychological detention. Interpretation of an ambiguous statement made must consider both what the officer most likely would have meant, as well as how a reasonable person would have interpreted the statement. We are submitting that the most likely explanation for Detective Van Gundy's statement was to caution the accused that if they don't cooperate with their investigation, more suspicion will be shed upon them. Detective Van Gundy had already witnessed the accused partaking in activity they claimed to be consistent with drug trafficking. If the accused are nervous or unwilling to answer questions, it may lead them to be suspected more. With his statement, Detective Van Gundy is simply illuminating the accused to this fact. The fourth stage in the encounter is when the officers ask the accused to exit the vehicle. At this point, the accused are considered detained by the officers and their Section 10 rights are triggered, to which the officers inform them of these rights. So based on these grounds, we submit that there is no infringement of the accused's Section 10 rights. Thank you very much.
Thank you.
So, Your Honors, I'm going to be presenting our arguments for issue 3 regarding the search of Ms. Powell's phone. And while the respondents argued that it was an unlawful search, I'm here to justify why the officer's analysis of the phone was well within their investigative rights. The judge acknowledges that the call logs and texts were within reason, but erred in his analysis that the photos were not relevant. This issue plays on the awkward relationship that rapidly changing technology has with slower changing law. Upon analysis, the search of the cell phone meets the judge's criteria under R.V. Fearon, which is the standard set for reasonable warrantless search in Ontario. The arrest was lawful, meeting the first requirement, since at the time of the arrest, the officers had more than enough evidence to proceed, given the circumstances they were currently in. For the second requirement, while the opposition might argue that the evidence could have been looked at later, in the case of R.V. Hisco, Constable Foley successfully argued that important data for drug busts need to be looked at immediately, stating that waiting past the point of arrest gives those involved time to cover their trail, while also leaving the possibility that online information could be corrupted, lost, or deleted. While this example was taken from outside of Ontario, we all share the charter, and so the principle should translate the same. The judge's largest issue was the third requirement, the relevance of the photos to the investigation. In his analysis, the judge fails to recognize the growing roles phones play in everyday life, especially considering the young age of the accused. Justice Stern claims that he did not think that Detective Burke had any reason to view the photos and was doing it out of curiosity, a notion I consider unlikely considering the gravity of the situation. It's not unreasonable that the officers thought that these photos might be relevant to the investigation. R.V. Fearon even cites photos as potential sources of search. This could be pictures of drug for advertising or of the accused using illegal substances. It could contain locations or photos with collaborators in their crimes. As long as the search is tailored to photos around the time frame of the arrest, they are unquestionably relevant, just as the communication of the call logs and texts might be. This precedent is backed up by a case like R.V. Cater, an example of when a cell phone was seized and the photos were considered admissible evidence taken without a warrant. The officers in this case had no significant grounds that the photos were specifically beneficial, and the search of photos relied solely on the officers inferencing that they could contain incriminating evidence. While Ms. Powell's phone is much more complex than Cater's in the other case, the subject matter that was viewed was the same, and the search of the photos was even less invasive than in R.V. Cater. The fourth requirement, regarding detailed notes of the search, marks the only inaccuracy in officer conduct. However, while notes were not specifically taken in regards to the picture and the video, this fourth requirement is less beneficial for shorter searches. The opposition argues that these notes were conveniently not taken down because the officers knew this was a violation. But this is very, very unlikely considering that they gave a description of the extent of the search undisputed by the accused. While we submit that this is an issue, considering the severity of the crime compared with the minute violation, there's no doubt that the evidence is admissible. Overall, under the judge's own requirements of R.V. Fearon, the search of the photos is unquestionably lawful. Numerous cases around Canada suggest this, and this case should become the standard that guides search procedure here in Ontario. Thank you.
So we will complete the Section 24 analysis using the Grant test, which involves 3 considerations: the charter infringing conduct of the officers, the impact of the breach on the charter protected interests of the accused, and society's interest on the adjudication of the case based on its merits. I will start by covering the admissibility of the statements made by Mr. Pete, and my colleague will cover the admissibility of the photo and videos of the firearm. First, I'll go over the seriousness of the charter infringing conduct. Psychological detention is an incredibly complicated and subjective topic. Although we are able to look back at the encounter with all the facts, Detective Van Gundy did not have this privilege during the encounter. They had to operate solely off of their perception of the situation at the time. We submit that if a charter infringement is found, it is simply the result of an understandable misinterpretation of a complicated situation, not the result of bad faith or incompetency. The second principle to consider is the impact of the breach on the accused's charter rights. The purpose of Section 10 of the Charter is to prevent individuals from providing self-incriminating evidence. Therefore, we must examine the nature of the evidence and how it was obtained. the evidence comes not from the content of Mr. Pete's statement, but rather the fact that the answer given was a lie. He was not tricked into doing this nor forced, but rather he told it of his own free will. We therefore submit that such a breach would have little impact on the charter-protected interests of the accused. The final point to consider is that the exclusion of the evidence would have a negative impact on the truth-seeking goal of a trial. The statement made by Mr. Pete is a very significant piece of evidence. The fact that Mr. Pete gave an untruthful statement, or an untruthful response, indicates that he had a reason to lie. He knew he had done something wrong. The statement is the only piece of evidence that comes straight from the accused, and therefore excluding it would inhibit the truth-seeking goal objective of a trial. So for these reasons, we submit that the statement made by Mr. Pete should not be excluded from evidence under Section 24.
If I could ask a question about that, there really were two questionings of two different people here. There was the questioning of Mr. Pete, in which he made the false statement, and then there was the questioning of the passenger who was asked to produce her identification. What is the relevance of the questioning of Mr. Pete to Ms. Powell's culpability, if anything? How would anything he said have anything to do with her?
Well, the fact that they were in the vehicle together, the statement as evidence would indicate the reason that they had to do something wrong, and the fact that they were together, as the officers observed, for the duration of what they considered was the potentially illegal events, would hold Ms. Powell to the same standard of suspicion as a statement given by based on a statement given by the other accused. Does that help?
Well, thank you. I understand your submission.
Okay, so I'm going to take away the next section. So in regards to the photo and video of a firearm, we again can justify the evidence using the RV Grant test. Or were you done, Zach? Sorry, we can again use the RV Grant test. Firstly, this arrest unquestionably warranted a cell phone search to some degree. The question becomes the photos. Considering the past cases when searched cell phones in similar arrests, past cases were searched cell phones in similar arrests, the officer conduct, if considered a breach, would be minor at most. They didn't try a new experimental search or push a significant boundary. They made a judgment call at the time well within reasonable limits. In regards to the lack of notes, this was an inaccuracy, but the purpose of the notes applies most heavily for extensive searches. Detective Burke was easily able to explain the subjects of research, and it remains a very small violation. Secondly, the impact of the accused was very limited. Detective Burke showed professional restraint by only viewing 2 photos despite finding significant incriminating evidence. This was an extremely brief search, showing no significant personal information other than the evidence itself. Furthermore, this information would likely have been viewed even if the officers had obtained a warrant, and maybe an even more extensive search. This information would be analyzed anyway, so if it was found that the immediate search was a violation, the impact would be very small. Finally, the evidence itself should not be excluded for the benefits of society. Firearm charges are very serious in Canada. In order to preserve our strict gun safety laws, it requires vigilance from Canadians and its legal systems. A charge as severe as this cannot be ignored. Furthermore, Justice Stern admits that these crimes are severe in his analysis, only erring in his analysis of the officer conduct to offset this severity. Under analysis of RV Grant, the benefits are too great and the errors too few to discredit this essential evidence. Thank you.
I'm sorry, counsel. Can I ask you a quick question, please?
Mm-hmm.
Is there any significance to the fact that when the officer was going through the phone, they first looked at the call logs and didn't see anything and then moved on to look to the photos?
That's a good question. I don't necessarily think so, because I think the justification that Justice Stern used for the call log specifically was that she was seen on the phone. And while I think that this is a good factor that helps, I don't think that's necessary for this kind of search to happen. In the case I brought up, RV Hisco, there was no such evidence of them using their phone during the crime, but still they looked at it considering the case, considering the wealth of information it could have. So even if they don't find that the calls during the investigation were relevant, I think there's still significant grounds to search the text and search the call logs and search the photos as it has been in other similar cases.
Thank you.
Good morning, Justices. My name is Delwyn Wells-Rousel. My colleague Isabella Villamonte and I will be representing the respondents in this case. In our argument, we will expand upon some of the key points of our factum, as well as address some issues in our friends, the appellant's factum. We will be highlighting 3 points of focus as part of our submission before you today. 1, that the accused Section 9 charter rights were violated when he was pulled over by the police officers, and that Mr. Pete was psychologically detained, therefore depriving him of his liberty to choose to comply with their request. 2, that the accused Section 10A and B charter rights were violated, depriving Ms. Powell and Mr. Pete of the right to counsel, as the officers didn't read them their rights in the appropriate manner during both detentions. 3, that the search of the photos on Ms. Powell's cell phone was a violation of her Section 8 charter rights, as there was no urgency forcing the officers to proceed without a warrant, and no notes were taken during the subsequent search. It is respectfully requested that, for these reasons, as per Section 24(2) of the Charter, all evidence found in this unlawful investigation be excluded. We now invite you to listen to the rest of the respondent's case, where we will expand upon our points. Thank you.
In R.V. Therens, the court laid out the parameters of psychological detention, physical detentions, and detentions by legal compulsion. Unlike our friends, we submit that in the case before us, Mr. Pete was psychologically detained and thereby deprived of his liberty to choose. We determined this by using the analysis from R.V. Grant that stipulates a psychological detention can be assessed considering the following: the circumstances giving rise to the encounter and how it is perceived by an individual, the nature of the police conduct, and the characteristics of the individual encountering the police. Of consequence, in R.V. Grant, the court determined that if a reasonable individual was psychologically detained, they would be deprived of their liberty of choice. In relation to the first step of the analysis, the circumstance giving rise to the encounter, a traffic stop, doesn't meet the threshold of a psychological detention. In regards to the second step, the nature of the police conduct, is where we submit the psychological detention occurred. In asking the accused about their whereabouts, Detective Van Gundy asked questions unrelated to the traffic stop. His aggressive and intimidating posturing came as a result of a reasonable question posed by Mr. Pete. In paragraph 51 of our friend's factum, it is stated that to avoid suspicion would be to comply with an officer's investigation. While this may be a reasonable assumption, it is not legally compulsory. We contend that this wasn't a lawful investigation, as the nature of Detective Van Gundy's intimidating interactions with Mr. Pete resulted in a psychological detention. In this so-called investigation, he did not refuse to comply. He was deprived of his choice. An outcome consisted in Grant. This is evident because Mr. Pete did respond to Detective Van Gundy's comments, and this statement was used to further strengthen the officer's grounds to detain him and Ms. Powell. In respect to the third part of the analysis, the accused in this case before us were around the ages of 18 and 20 years old, and were unsophisticated in terms of the law, which was also a consideration in R.V. Grant. The appellants indicated that the accused were not of minority status. In fact, we do not know this to be true. While it is omitted from being explicitly stated, it could be a contributing factor that raises the spectrum of more concerning matters at play, such as racial biases informing the officer's actions. Moving on, when cases arise from anonymous tips, that information can be assessed using the analysis set out in R.V. DeBow, which states that the tip must be credible, compelling, and that the corroboration by police happens prior to investigation. We submit that the first two factors were not met, considering the knowledge of the source is unknown and that the tip itself was very vague in terms of the vehicle type, location, and the observed behavior. Additionally, the tip was fairly generic, which generates greater suspicion to determine if this was a rumor or firsthand knowledge. In regards to the corroboration by police, we submit that this factor is partially met, considering police did see actions that were consistent with drug trafficking. However, in R.V. DeBow, the judge stated that if the informant's credibility is unknown, the corroboration must increase in risk of innocent coincidence. We submit that the officers did not corroborate the information prior to their investigation, as they did not check for other evidence or tips related to this incident. As a result, we respectfully submit that the accused were psychologically detained and their detention was therefore arbitrary. In regards to the second issue, I will outline some of our main points to the argument that Mr. P and Ms. Powell's charter rights 10A and B were violated. In R.V. Bartle, the court examines the obligations of police officers in situations where their Section 10A and B charter rights are triggered. In that case, the court found that at a minimum, the accused should be informed of their rights to counsel and duty counsel by the police, along with reasonable opportunity for them to assert this right. In our case, the officers failed to inform the accused of their rights to counsel and duty counsel. Considering the accused were between the ages of 18 and 20, we submit their knowledge of legal matters, including their counsel rights, were fairly limited. In R.V. Evans, the importance of understanding the right to counsel is highlighted, as an individual cannot exercise a right they don't understand. In the case before us, the officers should have made a greater effort to inform the accused of their rights after the physical detention in order to adequately satisfy the right to counsel of the accused. Both R.V. Calderon and R.V. Subaru highlight the importance of counsel and its role in protecting individuals from involuntary self-incrimination. The officers' efforts in this case before us took advantage of the accused's lack of legal knowledge in order to acquire more evidence in support of their investigation. The accused were never given the opportunity to contact counsel when questioned about their whereabouts, and as a result, Mr. P answered without legal presence. They were also not given access to legal counsel after being physically detained and when searched, which my co-counsel will explain later. Ultimately, they were vulnerable to self-incrimination brought on by the officer's lack of care with regards to the accused's rights. The appellants, however, argue that the question asked by Detective Van Gundy was simply part of general investigative questioning. We submit that since it was just a traffic stop, there was no need for general questioning, as there was no investigation underway as perceived by the accused. Of note, police must cease questioning until the accused have exercised their rights to counsel. If their question about whereabouts were crucial, they should have waited for counsel. This brings up a bigger question of why.
Just if I can interrupt you for a moment, when is it that you say that the police should have advised the occupants of the car of their rights to counsel, precisely?
So we submit that most importantly, they should have explained their rights to counsel during the physical detention in order for the accused to understand what this right was about. Also, when asked about their whereabouts, which was an unnecessary question, in terms of what the accused perceived the encounter to be about, which was a traffic stop, that was unnecessary in that terms. And then, but most importantly, they were not explained their rights in the appropriate manner when physically detained. Does that help?
That's fine. I'm just trying to pinpoint in time when it is the officer should have done it. Should it have been after they asked for the license and insurance, and when they weren't allowed to proceed at that point? Should it have been at the very time they first approached the car? Or that's what I don't really understand from your submissions.
So when they did ask for license and registrations, they went back to the car and ran the accused, and they had no criminal record at that point. When they came back to the car, when they returned back to the car where the two individuals were, the Detective Van Gundy asked about the accused's whereabouts. At that point, because that was an unnecessary question, they should have been advised that they were allowed to counsel with legal advice in order for them to make a statement that was not self-incriminating. And then once the police were advised the individuals that they were under investigation for drug trafficking, is when they then should have advised them again of counsel when that physical detention occurred.
Thank you.
Okay. So of note, police must cease questioning until the accused have exercised their rights to counsel. If this question about their whereabouts was crucial, this could have waited for counsel to be present. This brings up a bigger question. Why didn't the officers wait to counsel before asking questions and continuing their own investigation? We agree that in order to obtain more evidence, the officers continued their investigation without counsel, allowing more self-incrimination to take place. To conclude, our friends of the appellants in paragraph 54 of their factum explain that police are only humans and not immune to bias. While we agree with this sentiment, we submit that this is the exact reason why we have the charter. It sets a minimum of standards and rights for law enforcement must to adhere to. This allows the best protection against their own opinions and biases to lead their decisions when it comes to the law. Ultimately, the Charter has the final word. For these reasons, we respectfully submit that the accused's Section 10 rights were violated. Thank you.
Section 8 of the Charter protects against unreasonable search or seizure. R.V. Farron explains how this applies to the search of a cell phone, giving us 4 factors which must all be met. 1. The arrest must be lawful. 2. The search must be truly incidental to the arrest and done promptly upon arrest. 3. The nature and the extent of the search must be tailored to its purpose. And 4. The police must take detailed notes on what they've examined on the device and how they examined it. My co-counsel explained the first factor, so I will focus on the other 3. The second factor, as explained on page 623 of R.V. Farron, shows that there must be an element of urgency in the warrantless search of a cell phone. In the case before us, there was not. While our friends indicated the search was urgent due to the possibility of a remote deletion of evidence, this is simply not true. Although it is not stated which type of phone Ms. Powell had, on an iPhone it is possible to go into the Settings app and, without a password, remove the ability to remotely alter the data contained on the phone. This would preserve the evidence and remove the supposed element of urgency. Even if there were photos of marijuana on Ms. Powell's phone, the officers could have waited for a search warrant. As the trial judge indicated, it is horrifying that the police could have observed sensitive and personal photographs on her private device. The decision to invade her privacy should not have been taken lightly. The third qualification states that the nature and extent of the search must be tailored to its purpose. In R.V. Powell, it was found that the search of an accused's cell phone did not meet this third Farron requirement because 1. There were no longer any pressing circumstances, 2. The search was no longer truly incident to arrest, and 3. A search warrant could have been sought. In our case, as explained, there were no pressing circumstances. As I will explain in the fourth factor, the second possible qualification cannot be met. A search warrant certainly could have been sought. The fourth Farron factor states that the police must take detailed notes on what they've examined on a device and how they examined it. In R.V. Farron, Judge Cromwell explained that record keeping is important in evaluating after-the-fact judicial review and to help police officers ensure that they are following the laws for searches incident to arrest. It raises suspicion that there were no notes taken while looking at the photos in the case before us. It would raise even more suspicion if there were notes taken on everything beforehand and then stopped when it came to the photos. Unfortunately, that's exactly what happened. While the appellants imply that this lack of note-keeping isn't of consequence, it certainly is. As explained on paragraph 87 of Farron, the Crown is responsible for proving that a search was incident to arrest and is lawful. The detective book cannot prove this. The fourth, and therefore second, qualifications cannot be met. In conclusion, as the judge explains in R.V. Jones, police officers have 2 choices: to use the power granted to them to be more invasive or to take caution with the privacy rights of civilians. Keeping this evidence, despite the clear violation of the qualifications, will go directly against the precedent set in R.V. Farron. That concludes the third issue. Are there any questions?
No, thank you. Go ahead.
The Court of R.V. Grant found that there are 3 categories of factors to consider when looking at Section 24.2 of the Charter. 1. The seriousness of the Charter infringing state conduct. 2. The impact on the Charter-protected interests of the accused. And 3. Society's interest in an education on the merits. Let's consider the case of R.V. Aucoin, where Aucoin was arrested for possession of drugs for the purpose of trafficking, after being pulled over and detained for an unrelated offense. In his judgment granting Aucoin's appeal, Justice Moldaver recognized that an unreasonable search breaches someone's expectation of privacy, which was, in that case, the pockets of the accused. He also stated that, because the evidence would not have been discovered if it weren't for this illegal search, it was considerably more intrusive. Ms. Powell's cell phone and her purse both had a reasonably high expectation of privacy. If not for the warrantless searches, none of the evidence found during or after would have been discovered. This is therefore considerably more intrusive and definitely has a negative impact on her Charter-protected interests. When Mr. Aucoin was asked what was in his pockets, he had not been informed of his right to counsel and believed he had no choice but to answer, which impacted his right to be protected against self-incrimination. In our case, one of the only reasons the arrest occurred was because of a statement given by a man not informed of his right to counsel and practically threatened by the police when he asked a simple question. In the case of Alvi Ahmad, where the only reason for the officer's investigation was an anonymous tip, the fact that they were pretending not to be police and asking the accused for drugs was considered valid for the following reasons. 1, there was no face-to-face interaction. 2, it was a phone call, so the accused could hang up freely and at any time. And 3, the officers were neither threatening nor offensive. Now, in our case, they were meeting face-to-face, and the ability to leave at any time was not granted. Even if these young civilians thought they were allowed to, they absolutely felt nervous in the face of these officers, who they knew held a lot of power over them. On top of that, the manner in which the officers behaved certainly seemed hostile. Going back to R.V. Grant, we see greater context for considering the admissibility of evidence, with the judge explaining that the main concern is preserving public confidence in the law and its processes. As we have explained throughout our argument, the charter violations were both severe and unacceptable. Allowing the evidence would go directly against the precedent set by previous judges and cases. We submit that violating the charter in a manner that negatively impacts two young civilians will bring the justice system into disrepute. For reasons above, it is clear that the evidence fails the Grant test and should be excluded. Are there any questions?
No, thank you very much. The court will now retire. We thank you for your submissions. We'll retire for 6 minutes if we can be placed into a breakout room, and then we will, it is now 9:36. If we can be brought back in at 9:43, that would seem to be appropriate.
Thank you very much. Thank you to everybody for their submissions. Just a reminder that the panel may find for either side, and they also may reserve their decision. In either case, they're also going to provide detailed spoken feedback to you at that time. So thanks very much for your submissions, and we'll see you in 6 minutes.
Thank you.
There we go. The most common phrase of 2020 and 2021, you're on mute. So I just want to congratulate all of you for your very able presentations. You have, you're equal to or better than some of the counsel that appear in front of us at the Court of Appeal, and you did a marvelous job on both your facta and your oral arguments. The making an argument by Zoom has challenges because you don't have the same cues that you might in a courtroom. You can't tell when a judge is taking notes or reading a case authority and when you should slow down or pause, and it makes it tougher in that respect. The other thing that people often forget is that you know, when you're on Zoom, even though you might be at home in your dining room, or you really are in court, and the eyes of the court and all the other counsel are on you. You know, we've had unfortunate experiences of counsel taking bites of donuts when they finish their submissions, and they think it's, you know, they're at home, so it's all right to do that. But you really are in court, and we're certainly conscious of that. The pacing is different. Everything is different about a Zoom appearance, and it requires a different kind of concentration to listen to arguments on Zoom. The thing that's important to remember when you argue appeals is that really you're making two different arguments. There's nothing that makes an appellate court judge's eyes roll more than having a lawyer simply stand up and start reading word for word their factum. That's not what oral argument is all about. You have your written argument, which is one thing, and then you almost have to plan and organize an oral argument that is different, but sort of complements your written factum, and that is where we see the most effective advocacy. And you all did a good job of that. One of the things that judges love are roadmaps. We like to know where we're going in the argument. You know, we have 4 points to make, Counsel A will address points 1 and 2. Counsel B will address points 3 and 4. And so we're sort of prepared and know where to go and what to listen for. You know, both of you, all of you had appropriate mannerisms, and you know, you did a great job, all of you. Now, we are to choose the best oralist for the purposes of the OJEN moot, and it's very difficult to do in circumstances like this where you all did such a great job. But I think the consensus of the panel is that Ms. Delwyn Wells-Rouswell should be the recipient of that award, and we appreciated the clarity of your presentation and its organization. I'll invite my co-panelists. First, Ms. Christina Emberley, if you have any comments you'd like to make.
Yes, thank you, Justice Pardu. I want to reiterate what she just said. You all did such a fantastic job, and it really was a pleasure to get to witness all of your submissions. Something that really stood out for me for both teams was how much for the appellants, you really rooted your arguments in the trial judge's errors, which is appropriate. That is what you are doing on appeal. You're trying to show that the trial judge made mistakes. And then on the other side, for Respondent's Counsel, you said a few times, you know, the trial judge was right to make this finding. Again, that is your role on appeal. And I thought that was very impressive. And I think everyone did a great job. You all used jurisprudence really well. Everybody used roadmaps. Yeah, I'm very impressed, and I'm really excited to see what you all do with your futures. Hopefully it's in law.
Ms. Binhammer?
I'll just echo what Justice Pardu and Christina have said. One thing I really appreciated was how attentive to detail all of you were in your arguments. You knew the specific time you wanted to say that the accused had been detained. You were very careful in comparing the details between your cases to other cases, which can be really helpful for the court to see what other courts have decided. And you were attentive to details in your presentations as well. I noticed a few of you gave page references, which is something judges find very helpful when they're listening to oral argument and appeal, especially a complicated appeal like this one, where they're going to have to go back to all the materials later and look up the quotes that you were giving from, Fearon, for example. So you did a really, really great job of being professional on all of those fronts.
Now, I'm going to leave you with the clerks, but before I leave the meeting, invite you, if any of the participants have any questions of me, go ahead and fire away. You don't have to be intimidated, but all right, that's fine. I'll, with my thanks and congratulations again, it's up to me to leave now, and I will leave you with the clerks to finish off the completion of this. And congratulations again.
Brent, do you have any concluding remarks?
Yes, well, thank you very much, Justice Pardu and Christina and Ms. Binhammer. Thank you so much for participating in this, and I'm sure your remarks are well taken by all our participants. So thank you once again, and we look forward to maybe seeing some of these participants come into the Court of Appeal at some point, but or working with them in the future. But great to have you on board with us today. So thank you.
Thank you. Goodbye.
Thanks a lot.
So before we get our clerks panel started here, I just wanted to, well, congratulations to Ms. Wells-Rouswell on her award. And I just wanted to give a little bit more characterization of what that award is about. Gloria Epstein, for those of you who haven't heard her name, was a co-chair of OJEN's board of directors and a real champion for OJEN programs, including the Charter Challenge. So upon her retirement from the board, it was decided that she would be honored with this award in her name to give the best oralist at every Charter Challenge finale. Justice Epstein graduated in 1972 from Queen's University, earning an honors Bachelor of Commerce. She's also a graduate of the University of Toronto Faculty of Law, earning her Bachelor of Laws in 1977. She founded one of the first Toronto-based law firms that was owned by a woman. She also lectures on the role of female lawyers in Canadian law and her own experience in being raised to the bench while raising 3 children. Justice Epstein, then serving on the Ontario Superior Court of Justice, ruled in M&H, a case that defined what a spouse is, so the definition of a spouse under the Ontario Family Law Act. And that was unconstitutional, Justice Epstein ruled, because it was discriminated against gay people. So the ruling was upheld by the Ontario Court of Appeal and the Supreme Court of Canada after appeals by the Ontario government and Ontario Premier Mike Harris. So she's done quite a bit for the practice of law and for the Court of Appeal and for the promotion of social justice in our province and our country. And it truly is an honor to award that to you, Ms. Wells Rosell. So you'll be receiving a plaque, and I'll reach out to Mr. Filipe to determine how best to get that to you, but we've got a plaque waiting for you. So congratulations to everybody again, and yes, congratulations to you, Ms. Wells Rosell. Okay, so with that, I'll turn it over to our clerks. And just maybe to get us started, I wonder if you could each go over kind of what you do at the Court of Appeal, how your jobs are different, and kind of the course of your activities during the day.
Sure. So I guess I should just start by introducing myself again. My name is Yadesha. I am currently at the Court of Appeal, and I'm clerking for Chief Justice Strathy. So my day is slightly different than some of the other clerks in the sense that working with the chief not only requires working on areas of substantive law, but also some of the other kind of court administration and extracurricular work that the chief is involved in. On the substantive part, it's just helping the chief prepare for his hearings as they arise, which can include reading all the materials, summarizing them, and providing any research that he might need to understand matters better. And then on the kind of extracurricular court administrative side, the chief sits on various committees, and he also does presentations in the public. So if he has any speeches or papers that he wants to write, I help him come up with some ideas and edit those for him as well. So that's my capacity at the Court of Appeal currently.
So I'm clerking for 2 judges, Justices Feldman and Horgan. So similar to Yadesha, I mean, there's a lot of different components to the work that we do every day. I would say about half of it is just research based. So typically we get many appeals sitting, well, so you get different sitting weeks, and during those weeks, you have many different appeals come in. Typically it can range between I'd say 7 to 10 range, with topics ranging from constitutional challenges to civil issues. So it's a wide range of work. It's a court of general jurisdiction. And with that, there's a ton of topics that we need to be aware of. And sometimes the judges want research on an interesting point that's come up in a case, or just kind of some issue fleshed out. So typically pre-appeal, I do a lot of work for my judges, researching questions, going through the material with them, discussing the case with them, and just trying to get a good grasp of what are the legal issues, what are the facts at issues in that case. And then post-appeal, there's a lot of work with some follow-up research, and then with actually editing judgments. So getting the final product out, clerks are very involved in that back-end process where we we verify the facts, we try and provide feedback on the decisions, and the judges do try and involve the clerks throughout that process. They're receptive to our opinions and feedback. So we're kind of an integral part of the entire judicial process. And I felt like I've been deeply involved in the cases that I've heard, and have been very fortunate in that regard, because it really is an interesting experience to see how you guys just did it with the oral advocacy, and then seeing how we take that on the back and how that ends up being relayed in the judgments. So you guys are all on a very good pace to actually persuade the court, which at the end of the day is the role of counsel. So just want to reiterate, great job, and yeah, hope to see you guys in the court in the future.
Hi, everybody. Yeah, congratulations again. You all did such a good job. I think we're all very, very impressed. In terms of the types of work I do, it's basically the same as what Yadesha and Chris have already mentioned. A lot of research, writing, and just the way that I try to describe being a clerk to people who don't know what it is I kind of say we're like an assistant and an advisor. So we do a lot of things just to help them get through the day, make sure their materials and everything are organized. But judges really rely on their clerks for like just the intellectual exercise of making sure that their judgment is correct and makes sense and is logical. And so they really do lean on you a lot. So there's so many, I mean, depending on whatever path you all take, if you do decide to go to law school, you know, I would really encourage you to think about clerking. You not only get to build a fantastic relationship with judges, which is not an opportunity that many people are afforded, but you just get exposed to every kind of law. And, you know, you're just learning so much every day, and you really feel like you're contributing to the legal fabric of Ontario, and then also Canada. Ontario Court of Appeal, I believe, is the busiest appeal court in Canada. So it's such a great opportunity, and you also get to form really amazing friendships with your fellow clerks, which has been personally a highlight of my experience so far. So yeah, all of our emails are online as well. If you ever have any questions or anything, you can certainly reach out. But I definitely, I mean, I can see all of you having really successful careers in law. So if that's something you're interested in, I definitely encourage you to pursue that.
Thank you very much for all your comments, and that's really helpful. Do we have anybody with questions for our clerk panel right now? I'll open it up.
Yeah, I had a question. So when you're actually working like with the justices, I would assume that, you know, as fact-based as it is, you might have like differing opinions from what they decide at times. Is your job more fact-based around getting or do you actually like sometimes present your thoughts on an issue to them that you think they might not have considered, or something like that?
So I'll start. I think we've all had similar experiences in that our judges have been very open to hearing our thoughts on legal issues as they arise. So, I mean, the extent to which they do so really depends, one, on their expertise in that particular area of law, and two, how much research and how much background we also have in those areas of law. That being said, you're right. I've had situations where I've disagreed with the Chief Justice, and on one occasion, I was very proud of myself. I was able to convince him over to my side. But, you know, on another occasion, he disagreed, and despite all the convincing, he is going to continue to disagree, and that's fine. But that's part of the intellectual exercise of you know, working at the court, and for the judges of being judges. So I'll let Chris or Christina add to that if they want.
Yeah, so I would say judges are definitely open to hearing your opinion, and I think it's helpful to also just consider like what the clerkship program is. So we're all recent graduates from law school, and their clerkships are always year-long contracts typically. There's like some exceptions at the Supreme Court where maybe it goes a little bit longer, but they're generally one-year contracts at the Court of Appeal and throughout the country, and clerkships go to recent graduates. And That's not because people wouldn't want to do a clerkship. Like, it's a great job, and many full-time lawyers would like to do it forever, I assume, if they could. But the reason that it goes to new graduates is because the court wants different perspectives, new ideas coming out of law school. So it's institutionalized in the program that they want your perspective, they want your opinion, and they value it. So I have had many discussions where we go back and forth on the law, and they're receptive to hearing it. Like, at the end of the day, obviously it's the judge's call, but the decisions are better when you get different perspectives on it, and that's also definitely a firm part of our job.
Yeah, I completely agree with what Yadesha and Chris have said. A big part of our role is just to make sure that the judge is aware of different perspectives and different ways that you can look at a problem. I have had situations where going into the assignment, I was at a complete opposite position from my judge, and at the end of it, I was on their position, and I've had it go the other way around. So it's really just, it's such a collaborative exercise. So you're there to help them work through issues and you know, come to the best decision for the public, because that's really, you know, what their job is and what they're trying to do. So it's a great experience.
Those are really interesting comments from everybody to hear that, because I know there are a lot of articling jobs and a lot of jobs even for years after law school where, as a junior, your opinion isn't given the same kind of value that it sounds like it is at the Court of Appeal. So that's really helpful to know. That's actually not something I knew going through law school either, that you have such kind of a back and forth with your mentors and your bosses. That's really hard to overstate how valuable that is post law school.
Actually, oh, sorry, go ahead.
Go ahead, Zach.
No, I just in response to the idea of law, like I'm in grade 12, so next year I'll be going to you know, doing undergraduate. But I was wondering, in terms of you know, in terms of going to law school, and because like law school is definitely a possibility for me, and of what I'm considering. I'm wondering, like, throughout your undergraduate, what are some things you can do to better prepare yourself for law school, like, you know, become a stronger candidate for law school, and kind of get into that realm of careers? Like, do you have any advice for the next, I don't know, 4 years if I want to pursue a career in law?
And could I quickly add on to that? I was wondering, what did you guys actually take in undergrad? Because I'm seeing all these different career paths where they lead from undergrad, and I'm curious as to what you guys took before law.
So for me, I did my undergrad, I started as a life science student in my first year, and actually switched into anthropology. Did not know I wanted to do law during my undergrad, even at the end of my undergrad. So I was someone who actually did a master's degree before I went to law school. And that ties into Zachary's question. You know, the 4 years that you are doing undergrad, if you don't know you want to do law for sure, that's fine. You can always come into law with pretty much any background, provided that you take the LSAT and have a competitive GPA. So the advice would be, you know, take what you're interested in. I don't think there's any like degree that you can do or any major that you can take that will give you a leg up necessarily. So take what you're interested in, try to do well, and then take the LSAT. If you can be involved, you know, at school in different capacities, that always shows that you've kind of lived a little and you've come to law with an educated understanding of like what it will likely look like and why you're interested in it, and just make you an overall more interesting candidate for the law schools to consider. But yeah, I fell into law actually quite last minute. I applied 3 weeks before the deadline. I was like, I think I want to go into law. So it was a frantic mess for me to apply, and I did the LSAT actually after I'd applied. So I was someone that actually came to this profession very, very last minute. But yeah.
So I imagine that I was similar to many of you, is that I envisioned going into the law for a long time. Since high school, that's kind of what I was interested in. Not to assume that that's exactly what you guys want to do, but this is, I mean, what you're experiencing now is beyond what I did in high school, and it's great that you're reading the law and citing actual law. So it's a great start if that's what you're interested in. Yeah, so I mean, in high school, that's kind of what I wanted to do. I went to U of T for my undergrad and law school. And in undergrad, I studied political science and sociology. But like Yadesha said, I mean, you can change it around. I originally went in thinking I was going to study political science and history. I ended up really liking sociology and just kind of switched it into that. There's no real disadvantage to the program that you pick post high school. I would just reiterate that you want to do something that you're passionate and interested in, because that will naturally lead to success in the program, and then those go hand in hand to getting into law school and opening the doors. I would recommend working on research and writing based courses if you can. It is, I think, understated. Like, you all did great in oral advocacy, but it is also understated how much of the practice of law is writing based. Most of your time won't be in court unless you practice maybe criminal law, then you're on your feet a lot. But a lot of your time is writing based. So hopefully you like writing and you can develop those skills. But reading your factums, I mean, you're all in a great start for that. So just continuing to develop those skills in undergrad is what I would immediately recommend. But in terms of, you know, there's no game to the system of what you need to do for getting into law school, as long as you're just doing something you're passionate about. That's what I'd recommend. I did my 4 years knowing I wanted to go into law and just focused on classes I was interested in, and so far it's worked out. So that's all I'd recommend. Just follow your interests and write as much as you can.
Yeah, I have to agree completely with my colleagues to just do what you're interested in. And there really is like no one path. I did 1 semester of science at McMaster, hated it, dropped out. Then I did a journalism diploma in Edmonton, liked that, didn't want to be a journalist. And then I did a political science and economics degree and went into law school. And I knew for a long time that I wanted to be a lawyer. But I took a 1.5 years off in between. I traveled a bit, I worked a bit. There's so many different ways to get where you want to go. I have a colleague who I articled with who her undergrad was in drama. And then she did amazing. She's published in legal journals and everything. So there's so many different ways to get where you want to go. Grades they're not everything, but they are important for your applications. So I think that, you know, just shows that when you are interested in what you're studying, you're going to care about it more, you're going to put more effort in, your grades will probably be stronger because of that. So the best thing you can do is just do what feels right to you. And if you aren't sure what you want to do right now, that's totally okay. You don't have to have it all figured out. I still don't know what I want to do. And I've graduated law school and I've articled and now I'm clerking. So, you know, just follow the path that feels best for you, I think is really going to lead you to success in whatever that looks like. One other little tip of caution, I did fail, full-on fail biology, and it didn't ruin my life. So in undergrad, so if you have an F on your transcript, you will be fine.
Those are great points. One of the most successful lawyers I know had an undergrad in microbiology and now practices in patents. So you can really go any route you want as long as you're passionate about it. Any other questions for our panel?
Can I ask a question? Just maybe like on behalf of students I've had before too. So we do the charter challenge in class, and every year when we have these case scenarios, I think there's also sort of this idea that there's like a right answer that students are looking for. And so I don't know if you can speak to that. So I think part of the challenge as a teacher is often teaching them how to think through issues and how to, you know, support with evidence, not so much this is the correct answer. And I think what is sort of your approach when you look at that? Because I imagine the cases are all novel, so all the circumstances are unique. So there's not sort of an expected, trajectory of what's going to happen. There's obviously case law and precedent, but there is sort of this like reflexive, like, am I right? There's always like, is this right? Or what happens if? And I don't know if you can speak to a little bit of that sort of, the creativity that's involved in terms of some of the legal decisions and thinking about it.
I see Christina smiling, so I'm gonna let her go first.
I think that is one of the best and most frustrating things about the law, is that if you ever look at any kind of lawyer meme or any kind of joke, it's always, it depends, because there's never a right answer. It's very frustrating. But it's also great because if you're advocating on behalf of your client, you can get creative, obviously within bounds, but that's the whole kind of process of being a lawyer, is looking at the law and, even things that aren't directly on point. Are they adjacent to the issue that you're working on? And the possibilities are kind of endless. So it makes for very, very interesting work, and everything's always different. And there's always, sometimes that moment where something clicks in your head and you're like, oh, actually there was this one case and it's in a different area of law, but I actually think it's analogous to this and I can use that. And sometimes those are the most persuasive arguments. You had used case law that wasn't from Ontario, but talking about how that's still persuasive. That's a really big part of the job. And I'm not saying it's not frustrating, and you will find yourself kind of thinking like that with a lot of things. I was doing one of those, verifies where you have to click everything that has a car, and there was a truck in it. And I was like, well, is that a car or is that a truck? So you will annoy all of your friends and family because you will never have a direct answer for anything ever again. But it's a really fun part of the job. And it just makes every day different, which I personally really enjoy.
Yeah, I would just add that I think this helped me kind of getting over the hump is a couple centuries ago in English common law, there used to be this idea that the right answer was just out there, and with the right combination of words, people would just extract the correct answer from common law as if it was just out there. And then once we actually thought about it, we'd know the correct answer, and then it would be done. And that position has largely been abandoned, and I don't think anyone really, even in the judiciary, just thinks that there's an objectively correct answer to a lot of these complex questions that get litigated. I mean, there's obviously precedents, and sometimes you can just clearly advise someone about what the legal repercussions will be. But when you're getting on complex questions like the one that you're mooting here, and that OJEN does with these moots, where you're talking about Section 8 rights and rights to counsel and these rights that are largely loosely defined for the purposes of being amendable to different situations that we can't anticipate. It is about, there's a lot of value questions in there, and it is a lot of just needing to be persuasive and think about what are the principles behind this. And often when you're talking about principles, they can go either way. So I think, that at least helped me to know that no one is under the illusion that there's just a correct answer to every question that comes forward. There is, there's persuasive ways you can approach something, and there's precedents that you have to use, but it is a lot more about just taking a step back and thinking about what we're trying to do with these charter rights or these provisions. And maybe in terms of more functional tip that I could give is the moot that I did in law school. They made us moot both sides, and so you have to do all the arguments for one side, and then you have to do all the arguments for the other side in front of different panels. And that exercise really helps you appreciate, makes both sides' arguments better because you see the flaws in both sides, but also make you appreciate that there really are two sides to all coins. So whether that's institutionalized in the program or you just want to take a step back and think, how would I present the argument for the other side? I think that can help you realize that, make your arguments better, and also realize the holes in it, and that these arguments can go many ways, and it's up to you to present it in a persuasive way to get the judges to agree with you, not necessarily citing like X law or X case and then thinking that you won.
Yeah, I completely agree with both Christina and Chris, and so I won't add too much, but I definitely appreciate the difficulty that can arise with trying to look for the right answer. I was a science and math kid in high school, so making that shift in law school was quite challenging for me, and I think what helped me get there was recognizing that it's hard to say that there's a right or wrong answer when things get appealed from a trial level all the way up to an appeal level, and then the Supreme Court disagrees with what was said altogether. And then the Supreme Court may disagree with itself years down the line. So I think understanding that there is no quote unquote right answer is what also allows the law to be flexible and to change with the social, political, economic context as time passes. It makes it suitable for the society we live in. And so if you think of it that way, I think it also helps you appreciate what the law is in a broader context.
I also have a question. Is there a specific way you do research or website you use when you're looking for past cases?
Yeah, so yes, when we get into law school, we're taught about the legal databases that exist, and there are particular websites. The most common one that is used by the public as well is CanLII. It is a public resource, it's free, and most of the cases that are litigated are published there. There are more specific databases as well, but these are paid for sources, and that's what we use at the court. The court obviously has access to all these other databases, including something called Westlaw and Quick Law, but these are paid sources. So if you were going to access them yourself, you wouldn't be able to do so.
If I can add, if legal research is something that you were interested in or have to do at any other point, I have found it's a very nerdy way to pass your time, but if you go onto CanLII's website or Westlaw or whatever program you're using and look at the help section, often they'll have tutorials on how to phrase your searches and what kind of connectors and things to use. I have found it has changed my life in terms of doing legal research. So I would really suggest, at any point in your life, if you have an hour or so free, to look through that, and it'll save you time down the road.
Those are some great, great words of wisdom and great resources. You're completely correct. A very nerdy way to spend your time and extremely helpful. I've just posted the link to CanLII in the chat if anybody's interested. It's CANLII. Any other questions for our panelists? Well, with that, usually we would have a nice lunch spread for you all, and but unfortunately, unique and challenging times, right? So thank you very much to our panelists. Those were some very insightful takes, and something that I would have killed for in law school and definitely in high school. So thank you very much to Christina, Chris, and Yadesha for participating, and thanks to all of you, and congratulations once again for making the final. Like everybody has said, we've all been extremely impressed the quality of your arguments, as our judges panel said, in some cases surpassed the quality of counsel. So it's extremely humbling to see such like legal knowledge and grasp of legal concept at your age. So keep on going, and thanks very much for your participation. With that, I'll close the session, and have a good day, everyone.
Thanks, everyone. Thank you so much for inviting us.
Yeah, thank you, and congratulations again.
Thank you, everyone.
Bye.